indicated you have a comment to make on this. We are listening to you.
Well, the line is a little faint, but I'm going to try and speak just very briefly, Sana. Like I told you the other time, I think sometimes we are tempted to think that if you are not a lawyer or you're not a judge, you don't understand what the law is. But I just want to ask a very simple question. Who passed this law? This particular law that we have, Article 97, I think it's and G, isn't it?
Yes.
Or is G and H?
G and H.
Yeah. Who passed that law?
Ordinary Ghanaians.
Okay, so that law was passed by the ordinary 33 million Ghanaians through their representative in Parliament, isn't it?
Yes.
Okay, so one will expect that we, the people who pass the law, equally understand it, and that we don't need to depend necessarily on the judiciary or a lawyer to tell you that what is written by us in black and white all of a sudden has another meaning. If you read Article 97(1), it talks about the tenure of members of Parliament. And it says that a member of Parliament shall vacate his seat in Parliament. Okay? Not his future seat in Parliament. It says his seat. A seat in Parliament. You see, there's common sense and there's logic. You're going to contest an election. You don't know whether you will win or not. I've heard very senior lawyers say that perhaps it's futuristic. Okay? He's contesting to be a member of Parliament in the next Parliament. But that next Parliament is not guaranteed by the law. But it's not guaranteed that you will win. So the Constitution, we the people, could not be referring to some abstract thing that may or may not happen. This is common sense. So the law says that a member of Parliament shall vacate his seat. Okay? So that means that we already know that there's a seat that you already occupy, not a seat that you intend to occupy. And that you will vacate that seat if you leave the party that of which you were a member at the time of the election. So it also presupposes that an election must have occurred. Okay? An election has already taken place, for which reason you're already a member of Parliament, for which reason you occupy a current seat. So if you leave the party for which you were a member of at the time of election to join another party, or seek to remain in Parliament as an independent member, or if you are elected as a member of Parliament as an independent candidate and then joins a political party, you must vacate your seat. So now, do we need a lawyer to explain the law that we ourselves wrote? We don't. I find this simple logic eluding people very strange. Okay, the whole essence is that, Sana, you see, you are representing people in Parliament, and if the judiciary so cares about representation, some people in Parliament, some Ghanaians have decided that independence of thought, devoid of partisan biases, is important for the deliberations in Parliament. So somebody puts himself up as a neutral arbiter in Parliament, that he is not going to vote or discuss things, national issues, based on partisan lines, and that he is going to approach his work as a neutral participant. And the people in his constituency believe that is useful, and therefore elect him to come and perform that function. Having gone on that ticket and won in Parliament, he now decides that he is now going to join another political party that has a bias, an ideological bias in the way they approach national politics. He goes ahead to register to become a member of that party, because you cannot contest as a member of parliament of any political party if you're not a member of several years, of a certain number of years. So he has moved from being a neutral participant in parliament. He has now registered to be a member of a political party, and you cannot campaign or win an election if you don't believe in the ideology and the policies of that party. So the question then is that while still sitting in parliament, as the fact remains that while sitting in parliament, having been voted for, the seat he occupies is a neutral seat, independent neutral seat. Now he has registered to become part of a partisan ideological bloc. The Constitution then says that because you have two identities now, both as a partisan animal of a political party and also as a neutral participant in parliament, we don't know which one informs your thinking when you come to sit in this house. And because your people voted for you as a neutral participant in our politics in parliament, you have to vacate the seat. This is common sense and this is common logic. And please let our listeners understand that the laws were not passed by the judges. Okay? The laws were passed by we, the people. And we passed those laws through our members of parliament. And if a member of parliament passes a law like this and behaves in this same manner, and you have a system that seeks to protect him, then I don't know whether the law is still the most effective tool in administering justice in this country. These are the things that happen, and people begin to feel like if you want justice, perhaps the law is not the way. So I think this is simple logic. Let's not talk law and constitutional provision. Look, Senator, the Constitution imposes a responsibility on the Speaker of Parliament. And these are the two responsibilities. That if the person seeks, okay, not just having committed the act already, if the person seeks, for example, at the time these MPs filed their nomination to be members of parliament, either as an independent or as a member of a political party, the speaker could have gone ahead to invoke this constitutional provision because they were seeking. Okay? In the case, if you listen to Speaker Bagman very well, he said that he's taking notice that the people have already filed. They have already filed to be members of a political party or to become independent candidates. Supreme Court is saying that the rules of natural justice was not applied, that they were not heard. I'm asking the question, heard on what? The law says that if you, for example, Speaker, somebody filed a petition before the Speaker and said, I have heard that so-and-so MPs intend to contest as members of parliament on a particular party, even though they are independent, and that I would like to investigate whether this is correct or wrong because it violates the Constitution. Speaker Bagman would have been required to find out from other sources, including the MPs, whether or not this intention is true or not. In this particular case, they have already filed. It is a matter of fact. So to go and call the guy, what justice, what natural justice, what are you hearing? That is it true that you have filed? Speaker already said that they have already filed. And once they are filed, the Constitution imposes a responsibility. The Speaker has no liberty to say that, oh, this is what I'm going to do. No. The law says that if somebody does this, he must vacate his seat, his or her seat. And the Speaker is the one enjoined to undertake this responsibility. It is not an optional responsibility. So please, let us not even worry ourselves with the legalese of it. This is common logic. And let us understand that this law was passed by us, and therefore we are the right people to understand it and to interpret it. I find it difficult that, because you see, the lawyers even will tell you that the law is in the bosom of the judge. What does that mean? And just an arrogant exclamation. The law is in the bosom of the judge. What it means is that what the judge says becomes the law. Because what we have written here in black and white is now subject, written by 33 million people, is now subject to the interpretation of one man or three people. Okay? So I think this is clear. Speaker Bagwin has a responsibility that is imposed on him by the Constitution. This is not a political gimmick. The people have already committed the act. It's a statement of fact. So if you're going to hear somebody who says, I have already killed someone, what are you finding out? If the law says that if you kill someone, this is your punishment, and the person says, yes, I have done it, you say, no, I didn't hear it. The people have been heard. The people have been heard and must be deemed to have been heard because they have already filed. They have spoken through their registration to contest as members of parliament, either as independent or through a political party. They have already been heard. And Speaker Bagwin has heard them, and the Constitution has heard them. This is very shocking to me. And I think as we move along, we the people must understand that we pass the law. The laws that have been written that the judiciary and the court interpret and arrogate their powers or whatever it is, was passed by us. It cannot be that we pass laws that we ourselves don't understand or cannot read and understand. We do. And they should continue doing what they are doing, thinking that we have the power. The law is in the bosom of the judge. Therefore, what the judge says, even if it's in contradiction to what we, the people, have written, it's still the law. They should continue doing that. It will come to a point where the people will decide whether or not the law and the interpretation of the law must be given to only one man or must be given to only a group of people, or whether the law itself is serving its purpose, or whether it is indeed the most effective way of administering justice. They should continue doing that. That's all I have to say.
Thank you. Thank you very much for sharing that thought with us.
Thank you.
Raymond Acha, I like